So today is a massive day for us here at the Daily Wire. We are so proud that we at Daily Wire fought this thing from the very start. We fought it from day one. We said we were not going to comply, and we didn't. And then we spent hundreds of thousands of dollars to fight this thing in court. We were the first company in America to file a federal lawsuit against the Biden administration, literally within minutes of them promulgating the regulation legally. We went to court in the Sixth Circuit Court of Appeals. We could not have done that without those of you who are members and who have helped make this happen for us. Please, if you're not a member, consider joining up today and helping us fight, because that's what we do here at Daily Wire. Head on over to dailywire.com/subscribe. For today only, promo code WINNING gets you 40% off an entire year's membership. So you can support us all year long. We have amazing content, but you're really helping the cause more than anything else. dailywire.com/subscribe. Use promo code WINNING because we're going to keep on winning to get 40% off that annual membership. The Supreme Court ruled 6-3 yesterday that Joe Biden's vaccine mandate via OSHA was wildly unconstitutional because, as it turns out, it is wildly unconstitutional. It is a violation of the separation of powers. It is a violation of the enabling act of the original body itself, OSHA, the Occupational Safety and Health Administration. And it was being used as a cudgel by the executive branch of the government to simply end around the constitutional process of working through a legislature. See, here in the United States, there's this thing called the Constitution. The Constitution mandates that if you're going to effectuate a major policy, you need to go through this thing called the legislature. The legislature is, in its turn, comprised of two separate bodies, the House of Representatives, which is apportioned according to population, and the Senate of the United States, in which each state gets 2 senators. I know this is really basic stuff, but apparently people on the left need to hear this. The New Republic today, the New Republic, I'm not even kidding you. They tweeted out today, the New Republic, which is supposed to be a sophisticated liberal magazine, quote, "The real Supreme Court ruling appears to be this. The Biden administration can only try new solutions to new problems if it runs them through a gerrymandered House and a filibuster-friendly Senate first." Oh, you mean you can only do things that you don't have the authority to do if you are given that authority by the Congress of the United States? Who could have suspected such a thing, except for everyone who has ever read the Constitution of the United States? It's just unbelievable. Okay, so the Supreme Court ruled 6-3 in favor of getting rid of Joe Biden's vax mandate. And the language was pretty strong here. We're going to go through it. And as we do, I want you to remember that there were 3 justices on the other side, Breyer, Kagan, Sotomayor. And those 3 justices on the other side ruled that the Occupational Safety and Health Administration, with no actual statutory authority, could force 100 million Americans to vaccinate because they had jobs. That is what the left of the court said. That an obscure agency that generally you have no interface with, that obscure agency granted power by an act in the 70s, suddenly had the authority to decide whether you had to vaccinate, whether or not you had natural immunity or religious objection or some sort of existing condition that prevented you from getting the vaccine safely, that you had to vaccinate or lose your job. 3 justices on the Supreme Court said that that was totally fine. And if Hillary Clinton had been elected in 2016, that would have been 5 or 6 justices on the Supreme Court of the United States. Because remember, President Trump got 3 picks. All 3 voted the right way in this particular case. All right, so here's what the court ruled yesterday. The Secretary of Labor, acting through the Occupational Safety and Health Administration, recently enacted a vaccine mandate for much of the nation's workforce. The mandate, which employers must enforce, applies to roughly 84 million workers, covering virtually all employers with at least 100 employees. It requires that government workers receive a COVID-19 vaccine. It preempts contrary state laws. The only exception is for workers who obtain a medical test each week at their own expense and on their own time, and also wear a mask each workday. OSHA has never before imposed such a mandate, nor has Congress. Indeed, although Congress has enacted significant legislation addressing the COVID-19 pandemic, it has declined to enact any measure similar to what OSHA has promulgated here. Many states, businesses, and nonprofit organizations challenged OSHA's rule in courts of appeals across the country. The Fifth Circuit initially entered a stay, but when the cases were consolidated before the Sixth Circuit, that court lifted the stay and allowed OSHA's rule to take effect. Applicants now seek emergency relief from this court, arguing OSHA's mandate exceeds its statutory authority and is otherwise unlawful, agreeing that applicants are likely to prevail. We grant their applications and stay the rule. Remember, this is a preliminary injunction because the rule didn't even go into effect. So, the Supreme Court then goes through the history of the Occupational Safety and Health Act, which was created in 1970. The act created OSHA, the Occupational Safety and Health Administration, which is part of the Department of Labor and under the supervision of its secretary. As its name suggests, OSHA is tasked with ensuring occupational safety, that is, safe and healthful working conditions. It does so by enforcing occupational safety and health standards promulgated by the Secretary. Such standards must be reasonably necessary or appropriate to provide safe or healthful employment. They must also be developed using a rigorous process that includes notice, comment, and an opportunity for a public hearing. However, there's an exception. You're allowed to also promulgate emergency temporary standards. Such standards may take immediate effect upon publication in the Federal Register. This is only permissible in extremely narrow circumstances. It's only been used 9 times before, this emergency authority. 6 of those times it was challenged in court. Only 1 of those was upheld in full. Okay, so the Supreme Court goes through the process by which the Biden administration created this OSHA rule. And the Supreme Court then points out that applicants are likely to succeed on the merits of their claim that the Secretary lacked authority to impose the mandate. Administrative agencies are creatures of statute. They accordingly possess only the authority Congress has provided, right? Congress says that OSHA can do X. OSHA cannot do X, Y, and Z. OSHA can only do X. And if OSHA proclaims that Z is part of X, OSHA has exceeded its mandate under its enabling act. The Secretary has ordered 84 million Americans to either obtain a COVID-19 vaccine or undergo weekly medical testing at their own expense. This is no everyday exercise of federal power. It is instead a significant encroachment into the lives and health of a vast number of employees. This is the Supreme Court. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. There can be little doubt that OSHA's mandate qualifies as an exercise of such authority. The question, then, is whether the Act plainly authorizes the Secretary's mandate. It does not. The Act empowers the Secretary to set workplace safety standards, not broad public health measures. No provision of the Act addresses public health more generally, which falls outside of OSHA's sphere of expertise. So in other words, it is true that COVID-19 is a threat inside the workplace. It is also a threat outside the workplace and everywhere else that human beings congregate. And as the Supreme Court is about to say, just because you have a job doesn't mean that the court can now do that OSHA can now do whatever it wants to you. So, for example, OSHA could not promulgate a rule saying that obesity is a serious problem at the workplace because there are people at the workplace and obesity is a problem. Therefore, it is a serious workplace problem. Therefore, you're not allowed to eat fatty foods at your workplace via OSHA regulation. There's nothing that would allow that sort of thing. The dissent protests we are imposing a limit found no place in the governing statute. Not so, says the Supreme Court. It is the text of the agency's organic act that repeatedly makes clear that OSHA is charged with regulating occupational hazards and the safety and health of employees. The Solicitor General does not dispute that OSHA is limited to regulating work-related dangers. She instead argues the risk of contracting COVID-19 qualifies as such a danger. We cannot agree. Although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. COVID-19 can and does spread at home, in schools, during sporting events, everywhere else people gather. That kind of universal risk is no different from the day-to-day dangers that all face, from crime, air pollution, or any number of communicable diseases. Permitting OSHA to regulate the hazards of daily life simply because most Americans have jobs and face those same risks while on the clock would significantly expand OSHA's regulatory authority without clear congressional authorization. The dissent, says the Supreme Court, contends that OSHA's mandate is comparable to a fire or sanitation regulation imposed by the agency. But a vaccine mandate is strikingly unlike the workplace regulations that OSHA has typically imposed. A vaccination, after all, cannot be undone at the end of the workday. Contrary to the dissent's contention, imposing a vaccine mandate on 84 million Americans in response to a worldwide pandemic is simply not part of what the agency was built for. That is not to say OSHA lacks authority to regulate occupation-specific risks related to COVID-19. Where the virus poses a special danger because of the particular features of an employee's job or workplace, targeted regulations are plainly permissible. We don't doubt, for example, that OSHA could regulate researchers who work with COVID-19. OSHA could regulate risks associated with working in particularly crowded or cramped environments, but the danger present in such workplaces differs in both degree and kind from the everyday risk of contracting COVID-19 that all face. And then they point out that the Senate of the United States actually voted against greenlighting exactly this procedure. There was a procedural vote that was brought up before the Senate, and the Senate symbolically said, we don't like this regulation, which is a pretty good indicator Congress does not mean to grant this sort of authority to OSHA. The Supreme Court says the equities do not justify withholding interim relief. We're told by the states and the employers that OSHA's mandate will force them to incur billions of dollars in unrecoverable compliance costs and will cause hundreds of thousands of employees to leave their jobs. For its part, the federal government says the mandate will save over 6,500 lives and prevent hundreds of thousands of hospitalizations. The Supreme Court says it is not our role to weigh such trade-offs. In our system of government, that is the responsibility of those chosen by the people through the democratic process, Although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given that agency the power to regulate public health more broadly. Requiring the vaccination of 84 million Americans simply because they have jobs certainly falls in the latter category. Okay, so that is the majority Supreme Court opinion 6-3. Then there is also the concurrence. And the concurrence goes further. This is from Gorsuch, Thomas, and Alito. We'll get to that in just 1 second because it makes some pretty important points about the legislative branch and why we still need a legislative branch in the United States. This really was a clash of massive ideas as to the future of the country. If this had gone the other way, it would essentially spell the end, truly, of anything remotely like the constitutional structure in the United States. Essentially, we would be living under full administrative fiat at the behest of the wild left, greenlit by justices on the Supreme Court if this had gone the other way. On to the concurrence in this case. This is Gorsuch, Thomas, and Alito. They say the central question we face today is who decides. No one doubts that the COVID-19 pandemic has posed challenges for every American, or that our state, local, and national governments all have roles to play in combating the disease. The only question is whether an administrative agency in Washington, one charged with overseeing workplace safety, may mandate the vaccination or regular testing of 84 million people, or whether, as 27 states before us submit, that work belongs to state and local governments across the country and the people's elected representatives in Congress. This court is not a public health authority, but it is charged with resolving disputes about which authorities possess the power to make the laws that govern us under the Constitution and the laws of the land. And essentially what they say is state and local governments have extraordinary plenary authority when it comes to regulation of health. This is not true of the federal government. The federal government's powers are not general but limited and divided, say the three concurring justices. Not only must the federal government properly invoke a constitutionally enumerated source of authority to regulate in this area or any other, it must also act consistently with the Constitution's separation of powers. And when it comes to that obligation, this court has established at least one firm rule. We expect Congress to speak clearly if it wishes to assign to an executive agency decisions of vast economic and political significance. We sometimes call this the major questions doctrine. OSHA's mandate fails that doctrine's test. The agency claims the power to force 84 million Americans to receive a vaccine or undergo regular testing. By any measure, that is a claim of power to resolve a question of vast national significance. Yet Congress has nowhere clearly assigned so much power to OSHA. Approximately 2 years have passed since the pandemic began. Vaccines have been available for more than a year. Over that span, Congress has adopted several major pieces of legislation aimed at combating COVID-19. It seems, too, that the agency pursued its regulatory initiative only as a legislative workaround. Okay, what's hilarious about that particular note right there, which is that OSHA created this because they couldn't get it done in the legislature, is that Ron Klain literally tweeted that. Joe Biden's chief of staff tweeted that, and then that tweet was cited as evidence by the concurrence in this case, saying, you guys can't do that, it violates the constitutional structure. So well done, Biden administration. I mean, you just admitted what you were doing, and the court caught you. What is OSHA's reply? It directs us to 29 U.S.C., U.S. Code, Section 655C1. In that statutory subsection, says the concurrence, Congress authorized OSHA to issue emergency regulations upon determining that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, and that such emergency standards are necessary to protect employees from such danger. According to the agency, this provision supplies it with almost unlimited discretion to mandate new nationwide rules in response to the pandemic, so long as those rules are reasonably related to workplace safety. The court rightly applies the major questions doctrine and concludes that this lone statutory subsection does not clearly authorize OSHA's mandate. That section was not adopted in response to the pandemic, but 50 years ago at the time of OSHA's creation. Since then, OSHA has relied on it to issue only comparatively modest rules addressing dangers uniquely prevalent inside the workplace, like asbestos and rare chemicals. As the agency itself explained to the federal court less than 2 years ago, the statute does not authorize OSHA to issue sweeping health standards that affect workers' lives outside the workplace. But that is exactly what they are trying to do right now. The concurrence continues. They say, why does the major questions doctrine matter? It ensures the national government's power to make the laws that govern us remains where Article 1 of the Constitution says it belongs, with the people's elected representatives. If administrative agencies seek to regulate the daily lives and liberties of millions of Americans, the doctrine says they must at least be able to trace that power to a clear grant of authority from Congress. And then the court continues, say, in this respect, the major questions doctrine is closely related to what is sometimes called the non-delegation doctrine. Indeed, for decades, courts have cited the non-delegation doctrine as a reason to apply the major questions doctrine. Essentially, the non-delegation doctrine says the legislative branch of the government cannot pass a law saying to the executive branch, do whatever you want. Right? That is a delegation of powers it cannot delegate. And so the way you can tell if the non-delegation doctrine has been violated is if there are major questions that have been left wildly open to the interpretation of executive branch agencies. Say the concurrences. The non-delegation doctrine ensures democratic accountability by preventing Congress from intentionally delegating its legislative powers to unelected officials. Sometimes lawmakers may be tempted to delegate power to agencies to reduce the degree to which they will be held accountable. If Congress could hand off all legislative powers to unelected agency officials, it would dash the whole scheme of our Constitution. The major questions doctrine serves a similar function by guarding against unintentional, oblique, or otherwise unlikely delegations of the legislative power. Sometimes there's ambiguity, and agencies take advantage, for example. Whichever the doctrine, the point is the same. Both serve to prevent government by bureaucracy supplanting government by the people. And both hold their lessons for today's case. This is the concurrence. On the one hand, OSHA claims the power to issue a nationwide mandate on a major question, but can't trace its authority to do so to any clear congressional mandate. On the other hand, if the statutory subsection the agency cites really did endow OSHA with that power, that law would likely constitute an unconstitutional delegation of legislative authority. Under OSHA's reading, the law would afford it almost unlimited discretion. And this is the key point. And this is the key point that the concurrence is making. The legislature still exists, and because the legislature still exists and ought to exist, OSHA does not have this authority. If Congress wants to pass a law like this, it actually has to make the case that it's going to pass the law like this. Okay, so in a second, we will get to the dissent, because to me, the dissents in this case are spine-chilling. They really are. They should chill your blood. And first, Jen Psaki came out yesterday, posted the decision from the White House. She says, don't worry, Joe Biden is still going to encourage businesses to implement the vax mandate. Here's the thing. If a business chooses to implement that vax mandate, that is now on the business. That business no longer gets to blame Joe Biden or the federal government. This also gives the lie to a lot of businesses that were saying, we're going to preemptively do this under the assumption that it was going to be greenlit by the Supreme Court. Now, you didn't have to. You guys didn't have to. You could have stood up for your employees. And here's Jen Psaki saying they're going to encourage businesses to continue this anyway.
The Supreme Court's decision on the OSHA mandate essentially means that in this pandemic, it is up to individual employers to determine whether their workplaces will be safe for employees and whether their businesses will be safe for consumers. So President Biden, you'll see this in his statement, will be calling on and will continue to call on businesses to immediately join those who have already stepped up, including 1/3 of Fortune 100 companies, to institute vaccination requirements to protect their workers, customers, and communities.
Okay, so they can encourage as much as they want, but that's not what they were attempting to do. They were attempting to destroy businesses that refused to comply. They were literally threatening businesses with $14,000 fines for every unintentional violation and $140,000 fines for every intentional violation. They would have bankrupted our company inside of a week. That was their goal. That was their explicit goal here. And it wasn't to shut down the virus, because they can't do that, not with Omicron. It was to control. That's all they care about. How's this for a title? Ben Shapiro Show subscriber destroys like button with clicks and logic. I'd watch that. Make it happen, gang.